Good afternoon. Apparently this is the difficult session, i.e. most people are either sleepy or had to leave, but we'll have a friendly gathering, and I hope the persons that remain will enjoy our topic. I'm delighted to be the chairperson for the fourth session of the Minerva conference this year that regards environmental harm during the Ukraine-Russia conflict. Without further ado, just a reminder, a disclaimer. My opinions are my own. Any opinion expressed by me throughout the session is mine and mine only and does not reflect in any way the opinion of my employers. Without further ado now, I would call Dr. Anne D. Nelt from the Faculty of Law and Institute for International Affairs, University of Hamburg. So Anne is a maître en droit from Aix-en-Provence. She's a senior research fellow and lecturer at the Institute for International Affairs at the Faculty of Law of the University of Hamburg. She holds a PhD from Göttingen, and she has conducted several research visits, among others, at the UN in Geneva. In her recently published monograph on armed conflicts and the environment, she analyzes the interplay of international humanitarian law and human rights law and international environmental law. And she has assisted several members of the ILC during the Commission's work on protection of the environment in relations to armed conflict. And Anne will be talking with us about the environment and Russia's war against Ukraine. So thank you.
Thank you very much. Let's see whether I get this to work. Yes, wonderful. First of all, I would like to start by thanking the organizers and hosts for a very smooth conference so far. I'm very much looking forward to discussing with you the topic of environmental protection and the war in Ukraine. I have brought an outline with me. It will be quite challenging for me since you just heard my PhD was on exactly this topic. I can talk for hours about it. I will stick to the 20 minutes, of course. But if there are any questions in the meantime, just take me away over a coffee and I'm happy to further discuss. So what are we going to do in the next 20 minutes? So I will start with setting the scene. We will then look into two different categories of environmental protection in armed conflict. First of all, direct protection of the environment, and second, indirect protection of the environment. You will see that we have come across about some of the norms that indirectly protect for the environment earlier today. And for context, I would also like to address other fields of public international law that may protect for the environment in armed conflict. And then I end with some conclusions. So setting the scene. We have become aware now with the ongoing war in Ukraine that war also impacts the environment. There have been several reports in newspapers, on TV, for the public addressing the issue. But before, this issue was already on the scene on the international level. The International Law Commission, for instance, has started in 2011 to address the topic of environmental protection in relation, so not in armed conflict, but in relation to armed conflict. Lawyers have been working on it. States, especially from Europe, are quite interested in this topic. So there has been some preparatory work going on, and now we are applying it to the field. Talking about the field, you see a map of Ukraine here, which dates back to 1 month after the beginning of the war, so it's not the current situation. But you see different sites that have a particular environmental risk in the areas where we have active conduct of hostilities. You see quite a few red spots here that are spots with high environmental risk. You see some nuclear signs. That's where nuclear power plants are situated, that have been in combat areas, that have even been directly involved in combat. So the situation when we talk about the environment is quite serious. There have been many reports about environmental impacts of the conflict. These reports talk about strikes on refineries, chemical plants, energy facilities, industrial depots and sites. There have been reports about pollution and contamination of Ukrainian air, water, and soil. The impact also regards water supply infrastructure. Water can be considered as a part of the environment. There have been reports about huge amounts of waste that have been reported that also has some environmental impacts. We have reports about affected areas, protected areas specifically, that have been impacted by the conduct of hostilities. And of course, the use of weapons also has impacts on the environment in terms of health risks. When you see this long list of different parts of the environment, one could actually ask, what is the environment? So what is considered the environment? And depending on the field of law, depending on peacetime law or wartime law, you might draw different conclusions. So the ICJ, in its advisory opinion on the legality of the use or threat of nuclear arms, concluded that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. That is a very broad definition of environment, to be honest. In IHL, we do have norms that address the environment. So Additional Protocol 1 in its Article 35 and Article 55 addresses the natural environment. The travaux préparatoires, so the negotiating history, however, does not really allow us to draw conclusions about what the environment is. So it's undefined, and also due to this undefinedness, it has never been applied, but I will get to that a little later. So how can we define the environment? And I have some thoughts I would like to share with you. So first of all, we could actually look into international environmental law. There are a few multilateral environmental treaties that are said to apply during armed conflict. So we have specific environmental law with a specific scope of application that tells us at least these elements are protected in a conflict. That's true for the World Heritage Convention, which has natural heritage sites, which are less popular than cultural heritage, but we do have natural heritage. We have the Ramsar Convention on wetlands, and we have protected wetland sites also in Ukraine. I will show you a map later on. And then there's the Biodiversity Convention, where we have diversity hotspots, where we also have indications that it continues to apply during conflict. Last but not least, we have human rights law. And over the past years, there has been a very progressive discussion on how human rights can protect for the environment, and especially with regard to the definition that we just saw from the International Court of Justice, health impacts are of course covered by human rights. There's a human right to water, so a water infrastructure can be covered by a human rights understanding of the environment. So that gives us some hints, the methodology behind how to use these different fields for defining in an IHL context is quite tricky. I can answer to that later on if you want to, but just to give you a general idea on how we can work on a field in IHL that is not that clear in terms of law. Turning to direct protection of the environment. I already mentioned Article 35, Paragraph 3 of Additional Protocol 1, and I have the wording with me here. It is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment. Seems pretty clear, but in fact it's not. It's not only that natural environment is not defined, the threshold of widespread, long-term, and severe isn't either. We have no idea what it means. There were some ideas during the travaux that were discussed, but there was no consensus. Additionally, it's a cumulative threshold, so all three criteria have to be fulfilled at the same time. Importantly, and this is something that is not that clear in the literature, I'm afraid, Article 35, Paragraph 3 is an ecocentric norm in IHL. It was passed and adopted by states for the sake of the environment without relation to the civilian population. That's very important. It's not about the survival of civilian population, it's purely about the environment. Article 51 is quite different there. Due to the threshold, and because in other conflicts some of the parties were not party to Additional Protocol 1, it has never been applied. So we cannot look into specific cases where it was applied, neither the Gulf War, which happened before the adoption of Additional Protocol 1, the Vietnam War, nor the Gulf War from 1991 were regulated by AP1. Additionally, when we talk about specific protection, we have the ENMOD Convention that addresses environmental modification techniques. We have less state parties. The threshold is almost the same, and it's an alternative threshold. But the manipulation idea behind this convention makes it quite difficult. It also has never been applied. So all we got in the end, and this is not because of the state parties or the parties to the conflict in Ukraine right now, but due to a lack of consensus among states when they concluded Additional Protocol 1, all we actually got is indirect protection of the environment, which means we have examples of implicit protection of the environment in the existing law. We already heard about objects indispensable to the survival of the civilian population. We heard about agricultural fields, for instance, that are enumerated there, which are parts of the environment, but they don't protect because of the environment. Very prominent in context of the war in Ukraine, works and installations containing dangerous forces. This regards dams. It also regards nuclear power plants that enjoy a specific protection that also has an environmental impact. Precautions in an attack also protect for the environment if they are applied correctly. We have to think about the environment during the conduct of hostilities. That's also something that the International Court of Justice stated. So environmental considerations are valid even during wartime. Pillage, of course, also protects for the environment, especially when we talk about natural resources, for instance. So that dates back to the Hague Regulation, but has been confirmed by the Geneva Convention number 4. And then there's the protection of property. Parts of the environment are property owned by individuals or by the public, and they also enjoy protection as property. If we talk about implicit protection, it's very important to consider the principles of IHL. So when we talk about the principle of distinction, for instance, we have military objectives and we have civilian objects. Per se, the environment is not a military objective. It can be turned into one by moving troops, for instance, but as such, the environment is a civilian object, and there has been a lot of discussion in how far the environment can be an object. So we are mainly talking about elements of the environment that are objects and thus protected. The principle of military necessity applies eventually, and the principle of proportionality, of course. When we talk about a balancing of interests, environmental considerations have to be considered. Here is another map where you see red spots again. These are protected zones in Ukraine, either based on national law or based on international law. And over here, we have an area where we have currently active hostilities going on, where the Ramsar Convention on wetlands actually has quite a few protected zones. So if we take the perspective of the Ramsar Convention that has protected zones, that also has a list of Ramsar sites in danger, it's quite interesting to consider this in the context here. So what does Ramsar tell us here? We have the so-called Montreux records, which is the list of sites in danger. It has been applied to armed conflicts in the past. I've mentioned some of the cases from wars before, also in case of the DRC, for instance, which is a civil war. And the records identify priority to sites for positive national and international conservation attention. What does that actually mean? Well, it means the contracting party, in this case Ukraine, if they wanted to, could address the committee that is in charge of Ramsar Convention and request the inclusion in the Montreux records. That would mean more attention, but that's not all. In consequence, they could ask for an advisory mission, which would help with technical questions, for instance. There would be experts and not only the people in charge of the convention that go there, that do a mission, that advise. There is technical and financial assistance that comes with it, and of course public awareness, which seems to be very important to the Ukrainian government in how they are shaping the discussion that's going on. Human rights were mentioned earlier. What human rights could be used in this case? There's the right to water. If you look into a General Comment 15, you will see that it also continues to apply in armed conflict and has even been specified in some instances in IHL. We have the right to health and, of course, the right to life. During the time the Russian Federation was party to the European Convention on Human Rights, we can even think about Strasbourg as a court of compliance. And that's what makes human rights in this context so attractive. We could rely on human rights mechanism for enforcement and compliance in order to get Russia stop or at least change its behavior in the region. So what are our conclusions? And this is very general. My colleagues will look into some of these aspects further. IHL protects for the environment. There's direct protection, but it has never been applied. We have indirect protection, which lacks implementations, if we want to be honest. So we have an implementation issue here as well. But there's a possibility for additional protection based on multilateral environmental agreements and also based on human rights. I hope I am still in the timeline. So thank you very much for your attention. If there are any questions, please just ask them later on. Thank you. It's rushing through. Yes. I was scared.
Bravo.
At the time, then, when the presentation started, was not.
No, I mean, Anne saved us 2 minutes exact, which is appreciative. Thank you, Anne. So our next presentation is, a report by Dr. Natalia Hendel and Professor Timo Korotki on titled On Razor Edge, Attacks and Seizure of Nuclear Electrical Generating Stations in Ukraine. Natalia will be presenting the report, and she's a research fellow at the Geneva Academy of International Humanitarian Law and Human Rights. She's also a professor of international law at the International Humanitarian University in Ukraine, and an associate professor at the Faculty of Law at Vilnius University, and a member of the Ukrainian Association of International Law. She was also a member of Ukraine's Interdepartmental Commission for the Implementation of International Humanitarian Law between 2015 and 2017, and she'll be presenting the report. Thank you.
Thank you for this opportunity to participate in this very important for Ukraine event. This conference is it's very important for us and for international community for all. We begin by briefly outlining the current regime of international legal protection for the nuclear power plant under international humanitarian law based on both general rules and special rules of IHL. The following is a general description of the criminal legislation of Ukraine to which we will refer. We refer separately to reports and statements by international organizations concerning incidents by Ukrainian nuclear power plants during the international conflict caused by Russian aggression against Ukraine. And firstly, it should be noted that the full-scale invasion of Ukraine by the Russian Federation is definitely qualified as a new stage of international armed conflict, which began in February 2014 with the occupation of Crimea. And in the period of international armed conflict, the north of the Geneva Conventions and first additional protocols to which Ukraine and the Russian Federation are parties shall be applied for both parties in this conflict. Also, the norms of customary IHL are applicable for this armed conflict and for protection of nuclear power plants. During international armed conflict, nuclear power plants and their personnel are subject to the general rules of international humanitarian law and the special regime established for works and installations containing dangerous forces. This regime is established by Article 56 of the first additional protocol and is limited for historical and legal reasons. The protection applies to, firstly, a limited number of objects, it's dams, dikes, and nuclear power plants. And with a tendency to interpret these norms broadly to other objects containing dangerous forces of nature at the level of customary IHL. Secondly, a limited number of situations only as a result of attacks and as understood in Article 49, paragraph 1, first additional protocol. And thirdly, limitation of the possible consequences of such an attack if it may cause the release of dangerous forces and consequent severe losses among the civil population, as it mentioned in Article 56 in first additional protocol. Nuclear power plants, like other civilian objects, are protected from attacks in accordance with Article 49, first additional protocol. The obligation of parties to armed conflict to take constant care to spare the civilian population, civilians and civilian objects in a military operation, as it mentioned in Article 57, paragraph 1, first additional protocol, and Rule 15, customary IHL, and is on a particular importance when it comes to nuclear power plants. Moreover, this obligation is broader in scope than Article 56 of first additional protocol, and is not limited to attack but binds parties in a military operation. The party to the conflict that controls nuclear power plant has obligation to take all feasible measures to prevent the release of dangerous forces, even prior to an incoming attack, and to refrain from any actions that would risk such release, as it mentioned in Article 57, paragraph 1, and Article 58C, first additional protocol, and Article 13, paragraph 1, second additional protocol, and in rules 15, 22, and 42, customary IHL. In situation of occupation, they must take all the measures in their power to ensure public order and safety. It is mentioned in Article 43, Hague Regulation. After seizure of Chernobyl and Zaporizhzhia nuclear power plants, the responsibility to ensure to safe operation and to the plant is on the Russian Federation. Therefore, during the qualification and development of mechanism to counterattack the illegal action of Russian Federation against nuclear power plants, namely the use for terrorizing the civilian population and nuclear blackmail in general, creating a danger or deliberately causing a nuclear disaster by the party that controls the objects, negligent or deliberate violation of the rules of operation of nuclear power plants, deliberate causing of a radiation disaster by the party to the armed conflict and control such an object, and acts of nuclear terrorism, it's necessary to use other international legal norms and regimes, both within and outside on IHL. If we talk about Ukrainian legislation, criminal legislation, as for criminal legislation of Ukraine, which applies to a territorial basis to the entire territory of Ukraine, including the territories of Ukraine occupied by the Russian Federation, among the special ones, it is worth mention in Article 438, violation of the laws and customs of war, which is equivalent to war crimes. The article is largely blank and provides for the application of international treaties on international humanitarian law, so qualify as war crimes. Another special rule in Ukrainian legislation is Article 441, it's Criminal Code of Ukraine, is about ecocide, which establish criminal liability for mass destruction of flora and fauna, poisoning of the atmosphere, water sources, as well as committing other actions that may cause an ecological catastrophe. Despite the technical and legal defects of this norm, they are actively used for qualifying crimes related to the armed conflict. We should mention that now in Ukraine we have more than 40,000 criminal procedures on one war crime and several criminal procedures on committed crime ecocide. And Ukraine has twice declared that it accepts the jurisdiction of International Criminal Court for war crimes and crimes against humanity committed within its territory. Now I will focus for legal qualification of the attacks of and seizure and the Chernobyl power plant, nuclear power plant. Russian armed forces took control and Chernobyl nuclear electrical generation station on 21st February 2022 and first day of full-scale Russian invasion of Ukraine. The Chernobyl plant's seizure of the station. On March 31, the armed forces of the Russian Federation left the power plant, taking prisoners of the National Guard of Ukraine and unit of the Ministry of Foreign Affairs who guard the Chernobyl plants. Non-critical equipment and hotel near the station were robbed. In particular, the analytical laboratory and radioactive waste management and its long-term archive were robbed and destroyed. Highly active tests and samples of radionuclides which were located in the laboratory were seized. The Chernobyl plant itself had no military significance, but according to military experts, Chernobyl was a convenient direction for offensive towards Kiev. At the same time, military action of Chernobyl and in exclusion zone posed a significant threat of radioactive pollution. In our opinion, despite the fact that although international humanitarian law does not contain direct prohibition on the seizure of objects similar to the Chernobyl plants, its seizure did not pursue any military purpose and threatened radiation disaster. There were numerous threats to Chernobyl personnel, prohibition of rotation, which significantly affected nuclear safety. Chernobyl plant's personnel worked without rotation for about 100 hours. Chernobyl plant's personnel are civilians and are protected by the general rules of international humanitarian law. In fact, there were violations of international humanitarian law against Chernobyl plant's personnel that had an impact on nuclear safety. A significant number of facts related to the Chernobyl plant's seizure may indicate negligence of radiation safety rules in the absence of military necessity, which caused significant negative consequences in terms of nuclear and radiation safety and could lead to an environmental disaster. In our opinion, such action go beyond the purpose of the armed conflict are unlawful in accordance with Article 1, Paragraph 2, Article 35, Paragraph 1, Article 55, First Additional Protocol, and Rules 45 and 44 of customary IHL. Also, criminal proceeding for violation of the laws and customs of war under Article 438 of the Ukrainian Criminal Code for war crimes due to the attacks and seizure of the Chernobyl plants and looting of the Chernobyl property and crimes against the Chernobyl plants personnel. We open against the Russian commanders who ordered the attacks, seizure and detention of the Chernobyl plants and its personnel. In our opinion, the Russian armed forces presumably violated the general and special rules of international humanitarian law, in particular, first, violation of the principle of distinction, for example, attacks on civilian objects, its violation of Article 23 of Haga Regulation and Article 52 of First Additional Protocol and rules 7 and 10 rules of customary IHL. Violation for the requirements for the use of precautions during the attacks, in particular Article 57 of First Protocol and rules 15, 16, 17, 18 customary IHL. Violation of Article 55 of First Additional Protocol and Article 43, 44 and 57 regarding the attacks of seizure, the Chernobyl, and the creation of conditions for radiation catastrophe resulting in the possibility of causing widespread, long-term and serious damage. Another violation is regarding ill treatment of the Chernobyl power personnel. Its violation First Geneva Convention, for example, it's Article 27, 31 and 34. Another violation for this situation for about Chernobyl nuclear power plants, it's about looting and destruction of laboratory property. It's we can qualify this action as violation of First Geneva Convention, Article 33, and Rule 50 of customary IHL. And also this action can be qualified as possible violation of Article 57 and 58 of the First Protocol on general obligation of spare the civilian population in the conduct of military operation and other rules relating the precautionary measure on the rules 15, 16, 17 of customary IHLs. Another situation with nuclear power plants, it's about legal qualification of attacks on the nuclear subcritical facility in neutron sources of the National Science Center, Kharkiv Institute of Physics and Technology. Several attacks on a nuclear research facility of the National Center were recovered, for example, on 6 March, it was attacked with MLRC, and 26 April, 25 June, and another days. This nuclear subcritical facility neutron source was directly damaged as a result of rocket and artillery attacks. We can fix a lot of information in reports of a lot of international organizations about the damage of these attacks for these institutions. And regarding the attacks of the National Science Center, Kharkiv Institute of Physics and Technology, in our opinion, this situation can be qualified as a violation by the Russian Federation forces and general and special rules of IHL. For example, principle and distinctions, attacks of civilian objects, and the violation of requirements for the use of precautions measures during the attacks, in particular. Article, for example, Article 57 and First Additional Protocol and customary IHL. And another violation is regarding for the attacks on the nuclear subcritical facilities, neutron source, and the creation condition for a radiation catastrophe, which resulted in the possible causing widespread, long-term, and serious damage, as mentioned in Article 55, First Additional Protocol. As for the special rules, in our opinion, there is a slight violation of Rule 42, customary IHL, taking into account its possible expensive interpretation, and the special rule of customary IHL of the prohibition of attacks on building intended for the science purpose, as it mentioned in Rule 38, customary IHL. Undoubtedly, there was an indiscriminate attack by using MLC, which is a violation of the prohibition on methods of warfare, violation of Article 51 of First Edition Protocol and Rules 11, 12, 13, and 71 of customary IHL. The another nuclear power plant is South Ukraine nuclear power plant, which was attacked too. South Ukraine nuclear power plant is the second largest operating power plant in Ukraine, located near Mykolaiv region. Active hostilities are taking place in Mykolaiv region, the region center of which is the city of Mykolaiv, which is constantly subject of indiscriminate attacks. There were several high-level threats to the South Ukrainian nuclear power plants. You can see a rocket in, if you can see, it's one of these rockets near South power plants. Taking into account the technical characteristic of the missiles, they flights over the South Ukrainian nuclear power plants indicated a deliberate violation by the Russian armed forces of general and special norms of international humanitarian law. In particular, it's for about a violation of the requirements for the application of precautions measures during the attacks, in particular Article 57, First Edition Protocol, and the rules of customary IHL, and it's about possibility of causing widespread, long-term, and serious damage to the environment. Also, this action can be qualified as a possible violation of Article 57 and 58 First Edition Protocol. It's the general obligation to spare the civilian population in the conduct of military operation, and other rules of precautionary measures. And last nuclear power station is the Zaporizhzhia nuclear power station. Yes, thank you. A lot of accidents and attacks were in these nuclear power plants in Ukraine, and it's one of the biggest and largest nuclear power stations in Europe, and that's why it was very important to protect not only the power states but in the personnel who work in these nuclear power plants. And conclusions for our presentation, I would like to say that firstly, the attacks for nuclear power plants shows that the Article 56 of First Edition Protocol has a high level of protection, but all situations which were happening in Ukraine shows that a lot of acts violated another norms on IHL for special protection on civilian objects, for about measures for precautions measures, and that's why it could be to change the this approaches to protect this nuclear power to this object in IHL. Secondly, IHL needs changes about protection, special protection for personnel who works in nuclear power plants, because it's a very high risk for these persons. And because they have protection as civilians, but they don't have the special protection as it's continue for their work. Because if we come back to Chernobyl nuclear power plants, Chernobyl personas works more than 600 hours without rotation. It's a big period of time and it was very stressful for this person and very high level for the can be for the damage of this action. And the third point is that it should be very big work about to document and fix the special violation of IHL committed in these objects in the nuclear power plants, because it's different special regimes. That's why it should be fixed and the last point, it's only a theory, but in practice, a lot of families in Ukraine bought for their families, and we do the same. For example, some potassium kalium nitrate tablets for protection for nuclear radiation, for example. Thank you for your attention.
Thank you, Natalia. Our next speaker is Dr. Saba Pipia. He's from the Georgian American University and also currently a legal advisor at the Diakonia IHL Center in Jerusalem. He holds a PhD in law from the Tbilisi State University, and he has, among others, been a visiting Fulbright scholar at the Michigan State University, a researcher at the Max Planck Institute in Germany, and so on. He was an invited lecturer at the University of Porto in Portugal and the University of ESC in Romania. And Saba will be speaking about how the Russia invasion in Ukraine affected non-human animals and from an IHL perspective.
Okay, thank you very much, first of all, to the organizers for inviting me to speak today here, and also to my fellow speakers and co-panelists for their brilliant presentations. Today I will speak about the protection of animals in the war in Ukraine. Actually, the idea of animal law and all the animal lawyers were trying to achieve is to consider animals as beings that deserve protection by their own and not to be part of any kind of other environment, property, or whatever. But this presentation still is under the environmental panel, which means that this was the most related, because the environment indeed is a very important factor in discussing the protection of animals during an armed conflict. Before I move on to the presentation itself, I had it on a different slide. I'm sorry, I had to do it first. I have a few, let's say, methodological points or kind of disclaimers which I want to start with. The first is that we all know that active hostilities and the occupation is still ongoing in Ukraine, so the information which is publicly available might not be the thorough and comprehensive for now. So the facts which are referred in my presentation can be just a tiny part of what actually happened and what can happen in the future. And also this comes with my third point, which says that some of the sources which are cited are not necessarily academic, because again, due to some scarcity in information and unavailability of public information, there is a very kind of shortage of academic publications. So mostly I refer to some news updates or the blogs, but all the sources which are referred to support the facts in the presentation are verified and reliable. Then wherever I will be referring to Russia's invasion of Ukraine in the paper or in the presentation, it needs to be underlined that this, I believe this is a clear violation of UN Charter and amounts to aggression under which is provided under the definition of General Assembly resolution. And therefore this, every time this reference could imply the illegitimacy of this action. Also, when we are talking about animals, the term animal implies a non-human animal beings. And again, for some people in the academics or politicians or, I don't know, even the ordinary public, sometimes it seems very unethical or sometimes even immoral to care about animals in wars when we have so much sufferings in humans. So the point which I want to make is that the caring more about the legal protection of animals during the war should not be understood as caring less about humans. So usually let's say this statement or idea is that, well, first we have to care about humans, and once the safety of humans are guaranteed, then we can care about animals. But I'm sure that none of you can recall any armed conflict where the safety of humans was always guaranteed, and then the parties to the conflict had nothing just to care about animals. So if we will be longing for that ideal world, that can never be materialized in the future. That's why we need to care animals in parallel with humans, but this does not mean that it somehow diminishes the importance of suffering of humans. So that's the kind of starting points of the presentation. And back to the presentation, the issues I want to cover within the coming 20 minutes is whether what kind of uses of animals can have in wars, and whether the animals can be indirect victims of the war based on the military operations, and what kind of operations can be resulted in animal victimhood. Then I will speak about the facts which have been already surfaced about the animal sufferings or use of animals in the war in Ukraine, and then whether the existing international humanitarian law rules can be applicable to the protection of animals. Then I will specifically speak about the protection of animals in zoos, the protection of dolphin populations in the Black Sea, and the practice of pet hunting to prevent starvation, which was slightly already covered by other presenters during the previous panel. And lastly, if I'll have time, also want to briefly talk about how the animal welfare law can be transferred, the rules of animal welfare can be transferred in the IHL either now or in the future. So when we think about animals in war, most of the people will think, well, what have animals to do in the war? But actually the history documented a lot of usage of animals during war, and we even could call it abuse of animals, rather the use of animals. So historically, in different conflicts, the animals like horses or donkeys were used to transport humans or materials or weapons. Pigeons were used to carry messages. The camels were also employed in some desert operations. Dogs, especially, were used for tracking or guarding or delivering messages, or also for detecting explosives and mines. Dolphins and sea lions also were trained to protect the harbors from the sea mines. Some reports also indicate that the cats were used to hunt rats. In World War I, for example, the glowworms also were used to illuminate at night for readings. Also, illicit trade in wildlife finances wars, because we know that especially in African region, the poaching of and illicit trafficking of wildlife animals by some armed groups are used to buy more weapons and just to continue their war efforts. Also, additionally, animals can also be used as a means for military experimentation to develop and test new weapons. The companion animals have been used to raise morale also in the armed forces, and also the hunting down the pets and pigeons or other birds was detected as a mean to prevent starvation, for example, during the siege of Leningrad during the Second World War. And this list is non-exhaustive. There can be any other usage of animals. But when we hear this, maybe we think that, well, those are very ancient methods, right, of kind of using animals in the war. But they are still highly relevant for even now, and the war in Ukraine once again demonstrated this. But apart from this kind of direct use of animals, they can again become indirect victims of wars through the conduct of different military operations, or the actions which are kind of result of the armed activities. For example, destruction of natural environment and biodiversity, of course, affects the species of wildlife fauna which live there. The mass displacement of persons for the reasons related to war usually leaves a lot of companion animals abandoned, but also displacement. Sometimes, for example, even during in Ukraine, the war in Ukraine, the civilians displaced in some natural areas to find a shelter, which caused this disruption of the wildlife faunas who were living there. In some instances, there were reports that, for example, during World War, the British government ordered to kill the pets because of the upcoming shortage of food. So there was almost 1.5 million companion animals were killed by their owners in 2 or 3 nights because there was instruction from the government. We know that most of the wars now are fought in cities, in urban settings, so we don't have wars anymore in the battlefield. So this urban warfare poses a serious threat to animals in the cities in captivity, for example, in the zoos or in shelters, because they are directly affected for the military activities around those zones. As I said, wildlife trafficking is one of the source for income for the military or paramilitary groups to continue their efforts, and this, of course, endangers some species and poses risk for their extinction. And also, use of starvation as a means of warfare can result in making people to resort to this life-saving practice of eating and hunting down animals just to survive. And again, this list of animal victimhood is also non-exhaustive. There can be also other situations when animals can find other situations of military activities which can result in animal victimhood. But as I mentioned, that for some people it might seem very ancient, but in Ukraine, for example, which is happening just now, there have been numerous and multiple reports about the use or even abuse of animals in the war. For example, as I said, the displacement of persons. We've seen a lot of images of the refugees who are leaving Ukraine with their own pets, which causes, of course, stress for them. But there are many of the pets and companion animals which are left aside and they are abandoned because the owners cannot carry them. The displacement can happen either internally or externally. It doesn't matter. The zoos in different cities in Ukraine, like in Kharkiv or Kiev, became targets of the attack by Russian forces. But at the same time, in some other cities, also animals starved to death due to shortage of food supply, because there was either blockade or the roads were closed or it was not safe to reach these areas. The horses were burned alive by Russians after setting fire to the horse stable in the occupied city of Gostomel. Also, we've seen reports that Russians bombed surrounding of the dairy farm in Agromel, which it was near Kharkiv, which resulted in killing of 3,000 cows or injuring. Also, the Russian troops cut off the feed supplies, which led to the death of almost 3 million chickens in one of the agriculture farms in the Kherson region. The one report suggests that the dog was stolen by Russian forces from the Azovstal POWs and given as a trophy to a Chechen leader, Kadyrov. Another dog who was also abandoned by the Russian forces during the retreat was taken and adopted by Ukrainian soldiers and enlisted in the combat training, specifically teaching to sniff out the mines. Another dog named the mine-sniffing dog named Patron made it to the headlines of also, probably you have all seen when the dog was awarded with the medal by the president of Ukraine for serving his country. Some sources also reported, and I think it was also mentioned by by speakers from previous panels, that the people in the besieged city of Mariupol resorted to kill their animals and cats and dogs just to survive. And also the scientists detected a rapid increase in deaths of Black Sea dolphin populations. which they said it's alarming and are mostly caused by the activities of Russian fleet and submarines in the Black Sea shores of Ukraine. So this is again the facts which are available for now, but we don't know what is the reality. And of course, the objective of this presentation is not to cover everything. So we just selected three practices. Let's say the one is the attacks against the zoos. The another is the protection of Black Sea dolphin population, and the third is the pet hunting practice in Mariupol. And I will speak about those three, let's say, patterns which have been detected. But before that, we have to ask the question whether IHL protects animals at all or not. The simple answer is no, because we don't have any clause in IHL which protects animals for their own sake. That IHL does not say that the animals should be protected because they deserve it by their own and not because they are part of anything else. But of course, animals can find indirect protection based on their status or category they fall under, or the location they found themselves, or the ownership, or their significance for the biodiversity, or their usage. So there are different, let's say, features which can determine what kind of protection can animals get. But all this protection will be indirect. So IHL does not directly protect the animals. That's the kind of starting point when we are asking about the protection of animals under IHL. So if we talk about the indirect protection, then we can qualify animals as a property, as a private or public, if they are under ownership of someone. There are some scholars who also suggest that animals can be considered as a civilian object. However, the commentaries to the AP1 does not really support that, because it says that objects, because we know animals move, right? They are movable, let's say, objects, if we can label them as such. But the commentary suggests that the object should be inanimate, so that should not be so. Like qualifying animals as civilian objects could face some complications. The wildlife fauna, of course, are qualified as a part of the component of the natural environment, and thus find their protection under the environmental protection clauses. Sometimes some of the scholars also consider that animals can be seen as combatants if they are involved in the combat functions and carrying weapons. But this also comes with the problems, because we know that the combatant privilege, the protection for combatant, comes together with the responsibility, and animals certainly cannot bear the responsibility because they are not rational beings. Animals can also be qualified as an objects indispensable for human survivals only in case if those are the animals which are used for like cattle, let's say, like as a kind of last resort for the humans to survive. And also in some traditions or cultures where animals are part of considered as sacred beings, it can also be considered as a part of freedom of religion, because we know that for the POWs, let's say, the parties, the belligerents, have an obligation to ensure the freedom of religion. So those are the kind of indirect IHL clauses which can be applicable to the animal protection in wars. And now we move to, I don't know the time. Okay, we move to the patterns, which I say when we are talking about the zoos in Ukraine, we have like three, let's say, the legal clauses which can be applicable to them. The zoo itself, without animals, just a zoo as an object, including its infrastructure, administrative building, or the territory itself, constitutes a civilian object unless it is used for military purposes and thus qualified and meets the criteria for military objectives. And therefore the zoo itself, of course, enjoys the protection against attack because it's a civilian object, but not the individual animals there, because we say that the individual animals cannot be considered as objects as such, right? But they can still enjoy protection as enemy property based on the ownership, whether those zoos are owned by public, municipalities, state, wherever, but it's under private ownership. One thing here is that the wildlife species which are exhibited in the zoos cannot be qualified as a part of natural environment, because the notion of environment involves the kind of course, it should be interpreted widely, but its component should be in a natural setting. And we know that zoos are not natural setting for those animals. So thus the environmental protection clause cannot be applied to them. But however, if zoos, some of the zoos who run the conservation programs and thus have the animals not for the purpose to be exhibited for the public, but to prepare them for introduction in the wildlife, then these kind of animals can be considered as protected under the environmental clause, because their primary function is to contribute to the biodiversity and provide the sustainability of the particular species. With regard to Black Sea dolphins, the idea here is that once the scientists detected that the rapid increase in the deaths, because the dolphins mostly communicate with the sonar signals, with the noises, and when the signals are intercepted by submarines or by the fleet, then they disorient and getting stressed and eventually ending up in the shores and dying, of course. So the question here is, because whenever we are talking about the environmental crimes, and I think in Ukraine also there are numerous, I think more than 100, maybe even like few hundred alleged environmental crimes in which the prosecution opened the investigation. But I was not aware, at least I could not find the source, whether the investigation has been launched on this particular episode, because most of the environmental crime referred in the sources are about the nuclear power plants, because the question here is whether the dolphins are still protected under environmental clauses of IHL, because we know that even if dolphins die, even if the entire Black Sea dolphin population dies, this doesn't have to do anything with the humans, right? It doesn't directly affect the human survival. So that's why we don't have that much kind of stressing on the importance of the Black Sea dolphin populations. But what I'm suggesting is that, and I will not repeat something which was already covered by my colleague Anne, that IHL protects the environment as such, and not because it's linked to the human survival. And that's why we still have to consider attacks against the Black Sea dolphins as an environmental damage. But after that comes the test of this widespread, long-lasting, and severe, whether this can satisfy the test, because as also was mentioned by Anne, this test has never been satisfied before. And there are some skepticals as well. For example, one of the most prominent scholar, Michael Botte, on environmental protection in armed conflict, he back in 2010, together with other authors, wrote that basically the test provided in the AP1 is very narrow, and in conventional warfare, it's completely impossible to satisfy this test and meet this criteria. I'm certainly not in a position to judge whether these numbers which are in the sources suggest that this amounts to widespread, long-lasting, or severe damage. But what I want to suggest is that the damage to dolphin population in Black Sea should be considered as an environmental damage, even though they are not. It's not directly linked to the survival of humans. And I think that's my last. Do I still have some time? Okay. Yes, so the last point is about the eating pets and birds by civilians and combatants, because the sources suggested that the people in besieged Mariupol had to resort to this practice, but also some of the sources suggested that some of the Russian troops also we are eating dogs, because their food ration, the ration packs which were given to them were either outdated and spoiled, or they were just sick of eating that. So the question is here is whether this is something which should be regulated by IHL itself, because eating pets or pigeons, for example, is not the violation of IHL per se, right? However, it can be a violation of the national laws. And for example, Ukraine indeed has a national legislation of animal welfare, but maybe this goes beyond the IHL. The point here is that this life-saving practice, even if we assume this in a normal situation, it can be illegal. Here, this is a last resort to survive, right? But then who can be responsible, liable for that? Of course, the belligerent and party to the conflict who creates this starvation, who use this starvation as a method of warfare. So what I'm suggesting is that the party to the conflict who use the starvation and siege warfare to kind of force civilians to do that should be held liable not only for the starvation, but also any kind of crime against animals, either national or international jurisdiction, which is not necessarily an IHL, because in IHL, as far as it is now, we don't have this kind of the crime any clause which would outlaw the crime against animals as such. So this is the last slide, which I will skip because this is more general. That was kind of left for that if I will not type. So basically, that's what I wanted to talk about, and I will be happy to answer your questions if you have one. Thank you.
Okay. First of all, thanks to brilliant presentations, I think. For me, it was difficult as a chairperson and someone who needs to remark on these presentations because they cover this really wide area of law, ranging from protection of the environment, so classic IHL question, to a report on nuclear facilities, into animal protection. And I tried to find something that gathers all of them together. Wasn't easy, and I know Yuval said in the previous panel that you chose those obviously presentation for a reason. So I guess one of the reasons is that these are all topics. Well, when I needed to find it, these are all topics that brings, in my opinion, the question or the relations between a special law that was thought perhaps outside of IHL, not to apply in times of conflict. And then at this point in time, some of us IHL experts are trying to find out whether it can complement IHL. And obviously this brings into tension our views of what is IHL and what it is supposed to regulate, and what laws could infiltrate or get into that notion or bubble of armed conflict. So I wouldn't let you comment now, and we have short time for Q&A, so I leave the floor to others.
Thanks. Yeah, I have two questions. Is that okay? One's for Anna and one's for Saba, maybe. So the question for Anna is about the implications that you think there might be in terms of the IHL obligations with respect to the environment that a party might have when it acquires a degree of control that amounts to effective control over territory and the law of occupation comes into play. So I think in a situation where the law of occupation applies, that degree of control introduces a set of obligations under IHL that are more robust than what you'd have. The logic changes a bit. And I'd be interested to hear your reflections on how that would influence its obligations with respect to the environment. And then for Saba, I was really interested when you highlighted that animals don't qualify as an object. But then it is interesting because it seems that IHL does sort of recognizes a few categories. So you have objects that are civilian objects or military objectives, and you have people who are fighters, combatants, or civilians, and that's the world. That's what there is. So it's interesting to understand then under IHL where animals fall. I mean, it doesn't seem that IHL recognizes a kind of interim category between humans and objects. But then, what is it? A vacuum? So happy to hear on that.
If you could pass to Michiel.
Yeah, thanks for very interesting presentations. Part of it relates to the last comment. Well, I have two questions as well. My first question is already partially asked, but I then would follow up on that. Like, if we have the negative definition in 52.1, and it's considered that you can actually would be able to attack an animal as being a military objective if it would approach you with like a suicide vest on. So then it can be an object in that sense. And indeed, is there then a vacuum if you say that 54 actually in the title refers to objects, and then it also inside the article refers to foodstuffs, but the commentary says that foodstuffs can include animals. And property can also be objects, but if animals can be so indeed, like, where does it fall? Why is it not just like it's a negative definition, so anything that's not a military objective is a civilian object, hence it also includes animals? So one, that's a specific question for Saba. Then a question maybe mostly to Anna, but it actually for all of you is, if we would be moving to a recognition of the importance of the environment and animals as not as purely anthropocentric, how it is now, at what point do we end up with a potential clash and get into trouble if you consider that? For example, if you look at Articles 55 and 56, we know that that around Chernobyl, the natural environment, the animals, they thrived afterwards. And there's areas in Africa, of course, where elephants are poached because of the armed conflict, but there's also areas where animals actually were able to increase in population size because of the armed conflict, because an area was not reachable because of an armed conflict. And a dam, it's called a dangerous force, just like a nuclear facility, because of the danger to humans. But dams generally mess up the environment. So if you bomb a dam and then the natural environment gets back its original kind of shape. So at what point, if the law does start developing, what point do we get actually into trouble as to considering what is good or what is the anthropocentric like purpose and then a possible like environmental purpose of IHL?
Thank you all for very interesting, diverse, but maybe still somewhat at some level connected presentations. And maybe I'll try to connect from my point of view and try to ask all three of you, how do you consider the epistemic or evidentiary issues which your topics raise in terms of how do you evaluate in real time that we are a long-term environmental harm or a long-term disruption to the animal, to the fauna, flora will take care? I mean, we know that in environmental law, I mean, that this is a very difficult in times of peace. I mean, this is a very difficult issue and precautionary approach, etc. But we know that when the ICJ was presented with an issue of that nature in a necessity defense kind of case, it did actually put the burden on the party arguing for harm. This is the Danube Dam, the Gabčíkovo case from a while ago. So my question is, to what extent do you consider, I mean, there would be some clear-cut cases, maybe direct harm to a nuclear facility, but how do you propose that we go about dealing with the more subtle, long-term, harder to establish harm? And just as really a side comment on the third category, yes, I mean, animals do raise an issue, but they're not the only category which is hard to categorize. I mean, also in this field of cyber issues, cyber warfare, there's this big debate over data. And what do we do with data? I mean, how do we consider it under the existing rubrics?
If it's okay, then I'll let the speakers to reply to all three questions. The question of responsibility, by the way, is also raised regarding AI. So again, with respect to animals and responsibility.
You want me to start? I don't. Okay, well, I can start and then we just do the tour. Thank you all for the questions, the very valid questions. I think I'm not talking about complimenting. Let's focus on the other ones first. So occupation. When we talk about occupation in the environment, we have a different framework. Of course, it's still IHL, but we talk more about natural resources. How can they be used? Who should be able to use them? If we have corporations, it's questions of due diligence that are of relevance here. We talk about the respect of the laws of the occupied territories, and there will be environmental laws in place place in the best case that should be applied, and all other applicable laws. So it's international environmental law, it's human rights law. So we have more peacetime law that gets stronger, that also applies to environmental protection in these scenarios. So I think there is more of environmental protection than you think of at first sight. The International Law Commission has extensively dealt with these questions and has pretty good commentaries in that part on it, I'd say. So I can recommend the commentaries to the draft principles on the law of occupation and the environment. I hope that answers your question. Second question, anthropocentrism, ecocentrism. Are we in trouble? Do we have to decide between either or? We don't. In international environmental law, we have treaties that consist of anthropocentric and ecocentric norms at the same time. And the same is actually true for Additional Protocol 1. Article 35, paragraph 3 is ecocentric and purely ecocentric, and all the other norms are anthropocentric. It's not that you have to decide, it can complement each other, and it's not that the objects of protection are in competition with each other. So I would say there are very little situations where you actually have to decide, but in principle it goes in the same direction. And when we talk about, and that kind of goes to the long run answer as well. So when we talk about the protection of the environment, of course it's because of the environment, but it's also in the long run for the people. But there was another thought I had when you were asking your question, Roger. So there is the paradox that when we have a contaminated area by landmines and people are kept out of this area, the environment thrives. Same is true for demilitarized zones. The moment there are no more humans, the environment is at its best state, of course. But that's not what the law in general is about. It's about making everything possible for both. And that's what the law is doing, not based on anthropocentrism and ecocentrism, but based on the combination that we have. I wouldn't play the card that you have to pick here. I think you can do it both.
One thing was maybe also should have clarified, or what I had in mind was thinking of, imagine you have to consider the collateral damage that may arise. If you have to take the effects on the environment into account, then you would normally take that as negative. But if there's actually positive effects to the environment, can you completely leave it out then?
That's a good question. I have to think about it. But yeah, I mean, if you're honest with yourself, you would have to consider that, I guess. But it feels kind of wrong at the same time. So I have to think about that. Long term and how to determine. So Article 35 actually says damage that may be expected. So we don't need proof. Some people have argued that we can actually use the precautionary principle from international environmental law and complement it here. The thing with long term is, like, according to Additional Protocol 1, it's decades. And even today, if Additional Protocol 1 was applied to Vietnam, it's still not sure whether long-term is fulfilled. And that's like the most long-term consequence we can think of. The soil is still contaminated. The health of the people is still affected. And Michael Bothe was mentioned earlier. Michael Bothe, he was part of the German delegation to the negotiations of Additional Protocol 1. And when I talked about it with him, he was telling me, yeah, states didn't want it to apply. There was public pressure. People wanted to talk about the environment and war. States adopted this norm, but they never wanted it to apply. So I'm not sure whether we should actually focus on the threshold, whether that will help, because there's still no state consensus on it. I think we should focus on what we got, and we got more than we believe. I think that's my take.
Okay, thank you for the questions. I will focus on animals mostly. Well, I think the reality which we have in the IHL is the following: that well, first of all, there is no clear answer on that, and even I mentioned that some of the authors suggest that, but some others contend this might be problematic. So it's not that it's yes or no, but the reality is that we have the term objects indispensable for human survivals. However, the interpretation suggests that it can be also animals, cattle, whatever, the one which are used for the humans to survive, right? Then we have a term environment, which can also be considered as an object, civilian object, as was mentioned by Anne. But the commentary also suggests that the environment, the components of the environment are like something, and inter alia also fauna, which is the only component of the environment which we can qualify as beings, let's say, right? Because otherwise the flora or the other things can be just considered as I don't know, like call it item or something, but at least the not the beings, right? And then we have these military objectives and civilian objects, which then the interpretation suggests that this should be inanimate objects. So that's kind of confusion maybe, that because from the one hand we have objects which can be kind of considered as something which is item or thing, and then whether can we qualify animals as such as item or thing? Well, probably back in the days it would not be problematic, because animals we are mostly considered as objects or items. But for now, it's a bit kind of shift in the mind of some societies, I would say, or some countries, where they growingly consider animals as something in between, persons or items. We have a very good concept of living property, for example, developed by one of the scholars, which I like personally very much, which suggests that there can be kind of property, but living property. So even the property clauses in the IHL includes like movable and immovable property. But again, movable property refers to some items or, things, right? The ones that are not moving, let's say, by themselves. Therefore, it's a bit difficult. I would not exclude like a qualification of animals as an object, but I would suggest that this is a bit kind of in conflict with some interpretations of what is object under what is considered object under IHL. But I would also agree, share the view that there might be also a gap, in the sense that if in the peacetime law we growingly acknowledge at some point kind of personhood for animal, which will be kind of in between of humans or items, then this should be also reflected in the IHL, which is not now, certainly. So this is, I think, like a very challenging part of the way how we find animals in the IHL. But again, this cannot be answered like a yes or no, yes, they are objects, or no, they are not. Because we have this kind of all these norms and interpretations which sometimes conflict with each other. Thank you.
Firstly, I would like to focus about what does Ukraine in this situation, about the activity of Ukrainian Ministry of Environmental Ministry. Firstly, every month, this ministry published the report of violation against environment during Russian-Ukrainian armed conflict. Secondly, in the website of this ministry, you can find the special program which you can public the situation which continues with environmental violation, and send the photos, the videos that prove to this violation for environmental during this armed conflict. The second point about how to fix this violation and this damage for a long period or for short period for environmental, which we can use the more forecasting and modern technology, how the environment can change for the using these weapons in the future. For example, it's some technical aspects of this problem. And another point, it's about responsibility. And now we know that is the initiative to make amendments for Rome statutes and to fix in the Rome Statute new crimes, ecocide, for example. The ideological of these amendments is full of sense, and the main idea why it should to do this, it's about to protect new generation, non-born generation, about to protect potential damage it can be for the future for using this weapon, and how it can change the environment, and how the change can change the lives of people in the world, for example. That's why it's very important. Firstly, protection. Then secondly, it's responsibility for this violation, criminal responsibility and personal responsibility. Thank you.
I see there are two more questions, so if it's okay, we'll take them quickly from Hadal and then from Jeff. Okay.
Thank you very much. I have a question for Anne. You mentioned that the natural environment should be considered as a civilian object, and also you mentioned the proportionality rule and the precautionary rule, and that also protect the environment. And I have a question that if every element of the natural environment should be considered civilian object, does it mean that every damage to a piece of soil or bush or rocks, whatever, should be considered incidental damage, therefore should be incorporated in the proportionality assessment, and the commander also should minimize the take feasible precautions to minimize this damage? Or is there any severity threshold that this damage should cross in order to be considered as incidental damage?
And while the mic goes to Joffrey, I will add that perhaps it's a good relay to Hadal that the question is also with respect to, does it turn military object if used, and what about the responsibility, obviously, for military operations lesser than attack in terms of constant care?
So my question is mainly to Saba, but generally, do you think there's value in drawing a dichotomy between deliberate versus incidental harm? Because what goes through my mind as I listen to the discussion is a simple reality that whatever we say the rules are, they have to be embraced by the forces that are executing operations. So how do you, one thing I would suggest is to think about ways you could influence military commanders to understand the value of placing these constraints on their subordinates. And I think it's much more logical when we get to the realm of deliberate harm. So for example, there's been a lot of discussion on the specific rules, primarily from AP1, but I think we skipped over a basic question. All action in war is necessity-based. Everything has to be derived from the principle of military necessity. So for me, the most fundamental question is, what is the necessity of killing or injuring an animal or destroying an aspect of the environment? If there's no, if it doesn't contribute to bringing about the submission of your enemy, then it's per se improper. And that's not necessarily a criminal proscription, it's an operational proscription. That's the first thing I would suggest to think about, is founding this at the inception on the doctrine of necessity. The second is, limiting violence, limiting destruction in war is an element of good order and discipline. Right? When I think of an ill-disciplined force, I think of a force that is just randomly and indiscriminately killing and destroying things, not necessarily humans, right? So a unit that goes down the road and is taking pot shots at stray dogs who've been abandoned by the population that's left here, that's an ill-disciplined unit, and that is a unit that you can expect will continue to go down that dangerous path of ill discipline, where it's not going to be a dog or a cat they kill next time, it's going to be the indiscriminate killing of a human being. I think if you look at the prosecution of the American sergeant who went off base in Afghanistan and murdered 13 Afghan civilians, there was evidence that before he did that, he was indiscriminately killing dogs, right? And so linking it or using kind of this operationally logical persuasion for commanders to understand, this is not just animal rights activists saying we have to take care of animals. This is directly related to you having confidence that the subordinates you put in the field are going to respect the limits of war, respect the principle of military necessity, and act in a way that's humane in an inherently inhumane context. I think the same applies with the natural environment. If you're just destroying something because you have the ability to do it, you're already off the bounds of legitimate military necessity. So I just, from the perspective of someone who's advised commanders, I understand the value of the very positivist look at the law, where this article and this article and this article. But fundamentally, there's an inherent principled foundation to the conduct of military operations and disciplined forces. And I think your scholarship and your persuasive effect of the scholarship you're using could really benefit from looking at that angle as well.
If it's okay, 1 minute per each, so we're funneled down. That's okay for practices.
Because the first question was to you.
Yeah, but that's like, okay. Sure. Okay. Now it's on. Thank you for the question. Based on your uniform, I guess you have some practical experience there, and I would like to answer my question with asking you a question. When you have other civilian objects in the vicinity, what do you do with them, and how far do you consider them in your evaluation of proportionality? And I can tell you what the ICJ has said. The ICJ stated, and I quote, "States must take environmental considerations into account when assessing what is necessary and proportionate in the pursuit of a legitimate military objective. Respect for the environment is one of the elements that go to assessing whether an action is in conformity with the principles of necessity and proportionality." End of quote. And I second with the ICJ here.
I think that part was reference to use ad bellum, not using bello.
That's questioned. That's disputed. Yeah, but I just got a minute. Constant care. There are scholars that say we have to take constant care for the environment. There's a principle of due regard for the environment. I think it's rather positive thinking to go that far. I don't think it's confirmed by practice, but we can think about in how far international environmental law, for instance, requires us to go further than we are currently going. But we can talk about it later if you want to. Thank you.
Yes, thank you, Professor. This is very important and very kind of thought-provoking question. Indeed, basically the slide I skipped was about how the animal welfare rule can be applied in IHL, and what I was suggesting is that any kind of, because now there's some kind of suggestions that for example, Martin's clause can be interpreted widely as to include animals in there or environment, let's say, right? But what I'm suggesting that any kind of interpretation of the existing IHL norms or introduction of a new norms related to animals will become subject of two main limitations, which is the principle of military necessity and the principle of humanity. So in other words, the interests of humans and the interests of parties like armies to the conflict armies of the parties to the conflict will prevail over the animal interest. Because we know that for military, the principle of military necessity even allows the parties to kill others, right? This is the reality of the war. So this is the kind of unfortunate reality which is in the war. So that means that also the rules of animal welfare can be somehow restricted, like compared to the peacetime application of animal welfare law. But I totally agree with you that at least like what I was discussing is something which happens beyond the military necessity. So it's this situation when, for example, we've seen that in Ukraine, the Russian occupation forces cut off the supply of food to the zoos. So I don't think there was any kind of rationale for military necessity to feed the zoos in the animals and don't to feed animals in the zoos and don't make them die and starve, right? But currently we don't have if we don't apply kind of IHL indirectly to animals, we don't have any kind of rule which prevents to do so. So that's basically, of course it's not military, it's not necessary from the military point of view, but it's not prohibited either as such to starve, let's say, animals in the zoos. That's why we need this kind of indirect application of existing IHL norms, which can potentially be kind of used as if we consider animals in the zoos as like property of someone, I don't know, or even if we consider it as a property, it will be hard to kind of find out that it was a kind of violation if you starve the animal, because this is the system which we have in IHL for now, unfortunately. Thank you.
Thank you. I would like to say two points about the responsibility and about commander's decision and actions. It's when we come back to Ukraine to Zaporizhzhia nuclear power station, for example, to change the legal status of this station and to include for Rosatom this station and another action which committed in Zaporizhzhia nuclear power station. It's not only a military decision, it's political decision, and we should say about responsibility of the Russian Federation as a state for this violation, for example, which committed in this situation. And another example, it's in Chernobyl was fighting in forest. It isn't any military necessity to do this action, for example, to destroy forest in this area. It's violation of IHL, of protection of environment, because any military necessity to did this, it was absent, for example. Thank you.
Unfortunately, our time is up. Thank you for this extremely interesting discussion, both to the panelists, but also to the audience that was quite vivid. I think we can resume for less than 10 minutes, like 8 minutes coffee and break, and then try to be here by, for the last session, if it's okay. Thanks.